Hello everyone, I'm the Mass Analyst. Those of you who have been watching my video for a while probably know a great deal about the Digital Millennium Copyright Act already. Now I've discussed this quite a bit in the past and I will continue discussing this in the future. I'm going to assume for the sake of discussion that you all know the basics of the mechanics of the DMCA, how the DMCA works. If you don't, then this discussion is probably not going to mean too much to you, so I would urge you to go and learn the basics. You can do this by either looking at some of my past videos or visiting my website, or there are plenty of other videos and websites that discuss this. So go out and learn the mechanics of the DMCA before viewing this. Now, this is going to be the first in a series of videos discussing one particular aspect of the DMCA. That is, what are the penalties if someone files a false DMCA complaint or files a false counter notice? I'll be exploring three cases in particular, and I'll be critiquing one of them extensively. The three cases are OPG versus Diebold, Rossi versus the Motion Picture Association of America, and Lens versus Universal Music Corporation. Now, Lens versus Universal Music Corporation deserves a hell of a lot of criticism because the judge made what I believe is a very bad decision that sets a very bad precedent. I'll go into that in great detail later. Before discussing that case, however, though, I have to discuss Online Policy Group versus Diebold and the Rossi case because the Lens decision builds upon these two other cases. You really can't understand Lens without understanding OPG versus Diebold and the Rossi versus the MPAA cases. So in this video, I will be exploring the Diebold case. The Online Policy Group versus Diebold lawsuit provides a perfect illustration of how the DMCA has the potential to undermine democracy. It's really very chilling when you look into it. Back in 2003, William Dell stated that he was committed to delivering Ohio's electoral vote to President Bush. Now, what makes this statement particularly ominous is that Dell was the President and CEO of Diebold. Diebold was, at the time, perhaps the biggest manufacturer of voting machines in the United States. I believe they're out of the voting machine market now. I'm not sure of that, but at the time they were the biggest manufacturer of electronic voting machines. I think of all voting machines, but particularly electronic voting machines. Unfortunately, Diebold's electronic voting machines were deeply flawed. A 2003 study commissioned by Maryland revealed that their machines had 328 security flaws. 26 of them were deemed critical. It would be incredibly easy for someone who was unscrupulous to manipulate the vote. Now, Diebold was aware of this, and they were sending emails flying all over the company discussing the flaws in their machines and what should be done. Unfortunately for Diebold, an archive of 13,000 of those emails were posted to the internet. Now, some of those emails contained confidential employee information, but many of them discussed the security flaws and possible implications they had for the integrity of elections. I'm going to post a link to my website and to another place discussing the history of Diebold. But you should actually go and visit my website and read the emails. They're really quite chilling. I don't want to spend the time reading them now. Now, after this was revealed on the internet, after the 13,000 emails were posted on the internet, Diebold did what any responsible corporation in their position would do. They fixed the problem, went on their way, and everyone lived happily ever after. Ha ha ha! Fooled ya! Fooled ya! Well, probably not, but no, they didn't do that. They tried to suppress this information. They sent out DMCA after DMCA trying to rid the internet of the archive. Now, Online Policy Group hosted a website that linked to the Internet Archive, and they sent DMCAs to the Online Policy Group's ISP. They sent the DMCA to the Online Policy Group, and there were some Swarthmore college students who had built websites featuring the email archive or linking to it. And they sent DMCAs to the Swarthmore students. Now, Swarthmore disabled the students' access to the internet. So as soon as Swarthmore disabled a couple of people's access to the internet, they would hand off the archives to someone else, and other people would post it. And so there was kind of a race between Diebold and the people who were posting these archives and linking them to it. People thought that there was a genuine public interest in this, that the elections could indeed be manipulated through someone unscrupulous because of the security flaws in Diebold's machines. And in all, Diebold must have sent out dozens of DMCAs trying to suppress this information. Diebold never actually filed any lawsuits against those who were posting the email archives. They were just content to play whack-a-mole by sending out DMCA after DMCA, trying to whack that mole down before it reared its ugly head and posted those archives somewhere else. Well, OPG and a couple of Swarthmore students, Nelson Chu Pavlovsky and Luke Thomas Smith, decided to fight back, and they enlisted the help of the Electronic Frontier Foundation, and they sued Diebold over this abuse of the DMCA. OPG and the students alleged in their complaint that Diebold was stepping all over their First Amendment rights, that they were violating their right to fair use, that Diebold knowingly made a misrepresentation when they sent out the DMCAs to try and suppress the Internet email archive, the email archive. Now I'm going to read you a few passages from the judge's decision. I'm just going to read you the important passages. Now this first passage is by far the most important. The judge said, "A party is liable if it knowingly and materially misrepresents that copyright infringement has occurred. Knowingly means that a party actually knew or should have known if it acted with reasonable care or diligence, or would have had no substantial doubt had it been acting in good faith that it was making misrepresentations. Material means that the misrepresentation affected the ISP's response to a DMCA letter." Okay, so pay attention. He said that knowingly means that a party actually knew or should have known. Or should have known. So that's going to be important in future analysis. The judge went on to further state, "The purpose, character, nature of the use, and the effect of the use upon the potential market for or value of the copyrighted work all indicate that at least part of the email archive is not protected by copyright law. The email archive was posted or hyperlinked to for the purpose of informing the public about the problems associated with Diebold's electronic voting machine. It is hard to imagine a subject the discussion of which could be more in the public interest. If Diebold's machines in fact do tabulate voters' preferences incorrectly, the very legitimacy of elections would be suspect." And finally, the judge noted, "The fact that Diebold never actually brought suit against any alleged infringer suggests strongly that Diebold sought to use the DMCA's safe harbor provisions, which were designed to protect ISPs, not copyright holders, as a sword to suppress publication of embarrassing content, rather than as a shield to protect its intellectual property. No reasonable copyright holder could have believed that the portions of the email archive discussing possible technical problems with Diebold's voting machines were protected by copyright." The judge came down hard on Diebold, and rightfully so. In all, Diebold had to pay $125,000 in fines because of their trying to suppress the speech, which is absolutely essential speech for the integrity of the voting processes, for the integrity of our democratic system. The Diebold case illustrates just how easy it is to abuse the DMCA to suppress information that may even be vital to the national interest, at least for a short period of time. It probably doesn't work very well over the long period of time, But who knows? If it hadn't been for the bravery of the OPG and a couple of Swarthmore students to fight back, who knows? Maybe the story would have been buried completely. But at least for the short period of time, the DMCA can be used to bury absolutely essential information. Now, this Diebold decision occurred in a federal court. It was the lowest level of the federal court system in the Northern District of California. That's the same court that is now considering the Lenz case, Lenz versus Universal Music Corporation. Unfortunately, the judge in both the Rossi versus the MPAA case and in the Lenz case have made decisions that show that the interpretation of 512F in Diebold is not the only interpretation, and in fact their interpretation is quite different. They interpret the term knowingly very different from the way that the Diebold court did, and it will make it much more difficult to sue somebody who files a false DMCA under their interpretations. I'll go into this in a lot more detail in future videos, but that's it for today. Well, this has been the Mass Analyst, under and in.